Law, Office Procedures, Chapter 3, Records and Documents. In this chapter, we will review the requirements set forth in the rules regarding record keeping. We will also discuss the obligations principal brokers and their licensees have to each other. The rule requires all principal brokers to keep a copy of all records pertaining to real estate transactions for 3 years following the year in which the transaction occurred. Record maintenance. The records must be kept available for inspection by the Division of Real Estate. The records should be kept at the principal business location of the brokerage. If the principal broker wishes to store the records elsewhere, they must request written authorization from the division. If a brokerage closes, the principal broker must notify the division of the location where the records will be kept for the required amount of time. The notification must occur within 10 days of the brokerage closing. The division must also be notified in the event of a brokerage bankruptcy. Once funds for a transaction are deposited into the real estate trust account, a transaction file must be opened and maintained for the transaction. All transactions must be sequentially numbered so they are easy to find in the event of an audit by the division. If a transaction or offer fails before the funds are deposited into the real estate trust account, it is not necessary to assign the transaction a number. A copy of the offer must be retained, but may be retained in a file containing all failed transactions which failed before funds were deposited into the trust account. Statement of account. The rules give buyers and sellers a right to a written status report of their transaction every 30 days. The rules refer to this update as a statement of account. A brokerage firm is only required to provide the statement of account upon request by either the buyer or the seller. Hopefully, brokers and agents are serving their clients well enough that clients do not need to rely upon their right to a statement of account to determine the status of their account. Brokers and agents should always keep their clients completely informed as to the status of their transaction. Closing statements. The rules require principal brokers to ensure that their clients have received or will receive a closing statement upon closing the transaction, which details all funds involved in the transaction. While the rules make providing the closing statement the responsibility of the principal broker, the title company usually prepares the closing statement. The closing statement must include the following: closing date, purchase price, itemization of all items paid and to whom money was paid, balances due from the parties, loans made, paid, or assumed. As we discussed in the federal law course, the federal government requires a certain form to be used as the closing statement on most transactions in which the buyer obtains a loan to finance the transaction. This form is referred to as the HUD-1 Settlement Statement. The principal broker is responsible for ensuring that the buyer and seller receive a copy of the closing statement. The principal broker must also retain a copy of the closing statement in their file. In order to document receipt by the buyer and seller, the principal broker should have the parties sign the file copy of the settlement statement. Death or disability of the principal broker. If a principal broker becomes disabled or passes away, the rules contain specific provisions for dealing with the change. If the brokerage is an entity, such as a corporation, LLC, or other legal entity, all licensees are considered to be on inactive status until a new principal broker is found. As soon as a new principal broker is found, the licensees affiliated with the brokerage may reactivate with the new principal brokerage. This situation is a bit different if the brokerage was a sole proprietorship. A sole proprietorship is a way to operate a business as an individual. A company or separate entity does not exist. If the individual dies or ceases to exist, so does the company. If the principal broker of a company dies, the company continues to exist. If the principal broker of a company dies, the company continues to exist. Business may continue as usual as soon as a new principal broker is found. If the principal broker of a sole proprietorship dies, a representative of the estate of the broker must do the following: notify the division and all licensees affiliated with the broker of the death or disability. Notify the division as to the location of the records and where they will be maintained. Notify each client that they are no longer bound by their agreements because the broker is no longer able to perform under the contract. Notify all parties to current contracts. Manage the trust account until all funds are dispersed or subject to a court order. Broker agent duties. Principal brokers owe certain duties to the associate brokers and sales agents affiliated with them. At the same time, associate brokers and sales agents have duties to the principal broker with whom they are affiliated.